Appeals, First Appellate District of Ohio, with the Honorable Marilyn Dias presiding, is now in session. Please be seated.
Good morning. Today's Tuesday, August 9th, and welcome to the First District Court of Appeals. Today we have 3 cases on the docket. I'm going to call all 3. The first case is actually submitted on the briefs, which is case number C220002, Hammond v. Lutz. The second case is case number C220013, Mehta v. Johnson. If attorneys can please identify themselves and their readiness to proceed.
I'm George Parker for the appellant, and we're ready to proceed. Good morning, Your Honors. Attorney Kevin Brewer here on behalf of the appellee. Ready to proceed.
Thank you. And I know one of the attorneys is running late, but the next case we have that will argue is case number C210440, State of Ohio versus Parker.
Sean Adams on behalf of the state, ready to proceed.
Okay. And you are appellee in this case?
Yes, ma'am.
Okay, thank you. All right. So we'll start with the Johnson case. Good morning.
Good morning.
Would you like to reserve time?
Yes, may it please the court, Mr. Brewer, Your Honor, I'd like to reserve 7.5 minutes of my time for rebuttal.
Okay. This is 2 days in a row that people are asking me for half minutes. Do you really think my clock manages half minutes?
Maybe I'd reserve 8 minutes,
Okay, I appreciate that.
and then I'll speak really quickly.
All righty.
There's a saying about pigs and hogs. Pigs get
I've not heard that one.
pigs get fed and hogs get led to slaughter, and that adage is particularly applicable to this case because in this landlord-tenant dispute, as applied, it's okay to make a profit when the landlord was leasing to the tenant, but when that profit is a result of price gouging and or taking advantage of people, you'll eventually lose in the end. You see, in this matter, the parties never agreed to a lease. An appellee knew from the very beginning that the appellant disputed the value of the leased premises. And in fact, the landlord's representative, who was his wife, negotiated and accepted different rents each month. But what was clear from the facts is
So there was no written agreement.
no written agreement.
So then it falls into a month-to-month, right? Tenancy,
Yes.
right?
Yes.
And so did the court look at the history and how the parties behave in determining the terms of that month-to-month tenancy?
No.
And how's that?
What essentially the trial court did was just said there was a rent and bond, that's the amount of the monthly rent, without there being any evidence presented as to the fair market value, other than the only statement about the fair market value as it being $500 a month.
But that wasn't the agreement. The parties agreed on a certain amount, and isn't that what the court looked at? Evidence of their agreement?
No, actually, the agreement changed on a month-to-month basis. It started off as one amount and then kept changing based upon the condition of the property.
I thought it just changed one time.
It actually changed multiple times. In fact, in May of 2019, the appellant began paying an amount of rent that was substantially less because of the condition
How
of the
much?
property. She actually paid $600 one month, $500 finally in June. So she had come to the conclusion that $500 a month was what she thought was fair. She was led to believe when she came here that the property was in a condition that was represented on the internet. She moved here from Colorado. When she got here, the property wasn't as was represented to her. In fact, the pictures that were shown on the internet were from the tenant before the tenant, prior to when my client moved in. And so the condition was completely different. So,
Was there any testimony as to whether she had an opportunity to review the property before she took occupancy of it?
I mean, it was the first day, I think it was January 2nd.
Okay.
So she like moved her truck here and moved stuff here, and that she didn't have a chance. And
So she was sent a lease agreement
yes,
and she didn't sign it
she did not.
because she didn't believe that the property was worth the amount that was in the lease agreement?
Nope, she didn't sign it because when she moved in, she started to notice that it wasn't the way it was supposed to be.
Don't people normally sign a lease before they get the keys and move in?
I mean, it depends. I mean, if the landlord really wants to lease it to somebody and the tenant really wants to lease it, that's, I mean, I do agree that this is a unique set of facts. The damages were granted was also strange because the evidence was simply clear that it was the landlord's representative who broke the garage door when she brought the police in to check on the appellant. And she says it was a check, but really she was coming in with the police. And they broke the garage door, and then they added insult to injury. She sends her the bill for it, and then make it even worse, the court ordered her to pay it. Along with the water bill, which also always stayed in the name of the landlord because the water bill was a significant issue of the reason why the appellant never entered a written agreement.
I suspect the appellee is going to argue that this really goes to the credibility of the testimony. How would you address that? Because wasn't there conflicting testimony with regard to how the garage door was broken and conflicting testimony as to who was responsible for paying the water bill? So how would you address that argument?
I would say that there was not conflicting argument on how the garage door was broken, but maybe the reason why the landlord wanted to go in. Because the landlord said, oh, I was going in to check on her to make sure she was okay. On the water bill, I do think that there was conflicting testimony about that, but what wasn't conflicting was that the water bill always stayed in the name of the landlord's wife. So,
Well, let me ask you that, Mr. Parker. It's my understanding that the Waterworks requires it to, the water bill does always stay in the name of the owner of the property because if the tenant doesn't pay it, guess who gets stuck with the water bill when they move out?
I honestly, Judge, I've never
Yeah.
heard that.
Yeah, I think that's the case.
Okay. Well, then why was there an issue of my client putting a water bill in her name? I mean, that was, that's,
My understanding from reading the record is that when you lease a property, you always have your name as the backup. So when the tenant moves out, it reverts back to the landlord.
okay.
So, but it wasn't the agreement that she was to pay the water.
No, my client, no. The agreement was actually for the month of January, the appellee agreed to pay it.
So the water was included in the rent? Is
Yes.
that, okay. And then now she's arguing that the fair market value of the property is $500. Does that include water?
Yeah, that's
Okay.
that's her all-in price. So you could just stop there and say that the landlord was responsible for the damages, but I want to ask you, and I filed supplemental authority, I want to ask you to revisit the case of Schwab versus Lattimore, because I think in Schwab versus Lattimore, Judge Painter in his dissenting opinion identified two important issues that you should set straight when deciding this case. And I know you don't bring up new issues on appeal, except there's an issue that I think that you need to clarify and set straight. And that's when the 3-day notice is not properly, doesn't have the proper content and its timing is not proper. I really think that you should revisit Schwab versus Lattimore and send an edict to the municipal court about these 3-day notices. You see,
So this is not an issue that you raised?
it's not an issue that I raised, but jurisdiction, subject matter jurisdiction is always, can be raised at any level, even sua sponte. And honestly, when I was looking at preparing for this case, I went back, looked at the complaint, looked at the 3-day notice. I got involved when the damages hearing was involved. I wasn't even there when the eviction was started. And I looked at that 3-day notice, and what I noticed was it was lacking in content and timing. I don't know. I did a comparative survey, and it was anecdotal, but the 3 days in Ohio is different in just about one out of every other appellate court area. Some courts say it's on the 4th day you can file it. Some courts say you can't file it if the weekend ensues. Other courts say you can't file it if the weekend and a holiday ensues. In fact, this 3-day notice was served on Friday, October 11th, 2019.
So are you saying defective notice deprives this court of subject matter jurisdiction over the appeal?
Well, no, I think it deprives the
trial
municipal court of having had jurisdiction to grant the judgment.
No, my understanding is your client moved out, right? Your client's moved out of the.
Yes,
Okay.
and that's why I would urge you to revisit Schwab versus Lattimore and to recognize that every landlord who files a forcible entry detainer case should be required to know, and tenants should be provided with uniformity and consistency. And there is uniformity and consistency in this court's jurisdiction because there's only the Hamilton County Municipal Court, I believe, that can issue writs of, well, common police court too, but writs of eviction. But do weekends lengthen? Do you exclude weekends in the 3-day notice? Because 3-day notice was given on the 11th. The weekend ensued. Monday, the 14th of October, happened to be a holiday, and it was filed on the 15th. It didn't give the 3-day notice that if my client were to live in Columbus or Toledo or Cleveland.
Isn't that issue's waived, right?
Well,
It was never raised.
I don't think you can waive subject matter jurisdiction.
Well, wouldn't it be moot if your client moved out?
And that's why I think you look at Schwab versus Lattimore and revisit the issue, what's moot or not. Because I think that this court, really, there's only 2 landlord-tenant cases in the last 20 years out of
So
this
the
court.
3-day notice was provided the 11th, you said? Is that right? The 3-day notice?
Yes,
was
ma'am.
provided the 11th,
Yes,
and the complaint was filed the 15th?
yes.
Okay, and the heart of your argument is that
The weekend and a holiday.
that their 3-day notice was not proper, there was no jurisdiction from the trial court, and so there was no jurisdiction to provide the order, which then divests us of jurisdiction to review the order. That's basically your argument, isn't it?
Now, I don't think it divests you of the right to review the order. We'd ask that you set aside the eviction order because a writ of eviction stays on somebody's record forever. And they should never have got the writ of eviction. And then also, I do think that because the appellee received more money than what they should have, that the issue's probably, the judgment should be ordered to be satisfied.
Okay,
Am I used up my 7 minutes?
let's see where you're at. Pretty much so.
Thank you. Thank you.
But I will
Thank you.
reserve the remainder,
Thank
the
you.
8 minutes. Thank you. So why don't we start with jurisdiction?
Good morning, Your Honors.
Good morning.
My name is Kevin Brewer. I'm here on behalf of the appellee, Tehran Mehta. May it please the court. With regard to the issue of jurisdiction, Your Honors, first of all, you should know that Mr. Parker advised me last night at about 6 o'clock that he was going to bring that issue up. So I think it's unfair and prejudicial in the 11th hour to raise that issue. I agree with Judge Krause that this was not raised at the trial level, so I don't believe that it's properly before this court. And I would also add that while the 3-day notice is certainly relevant in most landlord-tenant cases, it goes to the issue of possession. And possession is not at issue here today. The only thing that is at issue here today are essentially money damages. So I think that issue that Mr. Parker raised can be and should be quickly disposed of.
So was possession ever at issue, or was?
It was, Your Honor, yes. This started out as an eviction filing, and a jury demand was filed, which prolonged the matter. Ms. Johnson paid her rent into rent bond for a period of time, stopped paying that. I motioned the court at that point to strike the jury demand, which the court did, and then we had an eviction hearing and a writ of restitution was granted. And if my memory serves me, this case goes back a little ways, but if my memory serves me, I believe that eviction hearing was contested. So it was at issue at one point, yes.
Okay. Now, she has subsequently moved, is that right?
Yes, she vacated in July of 2020,
Okay.
yes.
So
Sorry.
I wonder your position on whether, even if there was a faulty 3-day notice, whether that would be moot at this point?
I believe that it would be moot at this point, Your Honor. I don't believe there was a faulty 3-day notice, but I believe that it would
Well,
be moot.
if there was, yes.
Yes, yes. Your Honors, I believe that this case is really kind of a factually driven case. And so I'd like to just highlight some of the facts that I think that are important. My client, the plaintiff, or the appellee, excuse me, resides in the state of Texas. He owns locally a single-family home that Ms. Johnson wanted to rent. Because he lives out of state, the lease agreement, the documents were exchanged electronically. Access was provided to Ms. Johnson before the lease was signed, which we all know now that it was never signed. Mr. Parker indicated that he believes that this was price gouging. I would just submit to the court that nobody forced Ms. Johnson to move into this home. She could have easily chosen not to. She could, if she thought that the price, the rental rate was price gouging or unreasonable, she could have not moved in. She chose to move into the home.
Well, I think there's a possibility the appellants would argue if she was coming from out of state and had all of her stuff in a vehicle, where was she to go?
Well, I don't disagree with you, Your Honor, that might make it more difficult, but she didn't have to move into the home. If she wasn't happy with the condition of the home, if she wasn't happy with the rate of rent that my client was asking for the home, nobody was forcing her to move in. I do realize that it might have been putting her in a pinch, so to speak, to try to find a new place in short order. But these allegations of price gouging, if that's the case, why? It raises a question in my mind: why move in to begin with? If this is so fundamentally unfair, why move in to begin with?
But was there any evidence presented as to the fair market value of the property at the hearing?
Your Honor, there was evidence presented about what these parties agreed to. And then there was Ms. Johnson's opinion
Right.
that she thought it should be $500 a month.
But nothing like comparable
No,
property
Your
or
Honor,
anything
not
like
in
that?
my recollection.
Okay.
No. Ms. Johnson moved into the property. She never signed the lease. She paid the first month of rent and the security deposit at $1,050 each, which is in accordance with what the lease said. Thereafter, she negotiated with my client's agent to reduce the monthly rate of rent from $1,050 a month to $1,000 a month. And at trial, the testimony was that the reason why that negotiation occurred was because Ms. Johnson said she couldn't afford to pay $1,050 a month and pay the water bill. So my client agreed to reduce the rate of rent to $1,000 a month to accommodate Ms. Johnson. For approximately the next 5 months while she lived there, she paid $1,000 a month. She stopped paying rent in October of 2019. Forcible entry and detainer eviction action was filed. As I mentioned earlier, that was delayed because of a jury demand. She was ultimately evicted in July of 2020. So in sum, Ms. Johnson resided in this home for 20 months. Again, because the lease was never signed, she was essentially a month-to-month tenant the entire time. And Ohio law is very clear: a month-to-month tenant can leave with a proper written 30-day notice. They can leave at any time. If this was price gouging, if she thought this was so fundamentally unfair, in my opinion, she had 20 opportunities to leave, and she never did. Thereafter, once she vacated, the second cause, which is what's before the court today, I believe, was heard, and the court returned a judgment in the amount of $14,870.82. Your Honors, I believe that the primary issue before the court is whether there is competent and credible evidence to support the judgment from the trial court. I submit to all of you that there is. The magistrate who heard this trial believed that there was, and the Hamilton County Municipal Court judge who reviewed the objections agreed that there was as well, and I would submit to all of you that there is. There's really kind of three categories here of damages which are before the court. The first is rent, which is the biggest of the three. Again, I think this is factually driven. I think the facts are clear. What was created was an oral month-to-month lease. There is an unsigned written lease agreement, but I think that shows what the intent of the parties was. It indicates the rate of rent was $1,050 a month. She paid that the first month. Thereafter, it was negotiated down to $1,000. She paid that for 5 consecutive months.
Was there a time where she paid like $600 or?
Yes.
Okay.
Yes, Your Honor. I believe it was, if I may step. That was in September of 2019, just before the eviction action was filed. It was a partial payment, and my recollection is that was discussed at the trial level. And my recollection is that it was a partial payment, that it was not accepted as full payment for that month. And the very next month, in October, is when the eviction action was initiated. Additionally, once the eviction action was initiated.
What was Johnson's testimony with regard to the $600?
My recollection is, Your Honor, that she testified that at that point that she was getting rental assistance from various local agencies. I think it might have been a church, and that they were only willing to pay so much money to assist her. That's my recollection. Once the jury demand was filed, there was a bond hearing held in municipal court, and an agreed rent bond order was issued, an agreed rent bond order. So everybody agreed to the amount, and it was set at $1,000 a month. And once that order was issued, she paid $1,000 a month for 5 more months. She lived there for 20 months, so she paid $1,000 a month for 11 of those months. The other 9 months, one of them she paid $600, and the other 8 months she paid nothing. So for 11 of those 20 months, she paid $1,000 a month, which is what my client believes was the negotiated rate of rent and what the trial court concluded was as well. Ms. Johnson has argued that
The bond amount is not necessarily the accurate,
I'm sorry?
You're basically arguing that we should look at the bond amount and use that to determine or to support. But, that could always be wrong.
Sure.
So shouldn't we be looking more at the behavior of the parties? And
I think that
testimony?
you should be looking at both. I think that the bond amount, again, this was an agreed bond. There was no dispute. There was at the bond hearing, Ms. Johnson did not contest the monthly rate of rent. This was an agreed bond order. So I think that's one of the things that the court should consider. In addition to the behavior of the parties, the payment history, I think those are all important factors in determining what the actual monthly rate of rent was.
how many months was the $1,000 paid before the eviction?
Before the eviction, she paid $1,050 the first month,
Okay.
and then she paid 5 months of $1,000, and then her last month she paid $600.
And was there also a $500 payment?
Well, yes, however, that was in July 2019, and she made 2 $500 payments that month. I'm including that as one of the $1,000 payments.
Okay.
So she paid at least $1,000 in rent for 6 months before the eviction was filed. Last month she paid $600 and then stopped paying.
Okay, thank you.
I touched on this earlier, Your Honors. The court concluded that Ms. Johnson was not entitled to any type of a rent abatement. The only testimony that I recall that was ever presented to the court about a lower rate of rent below $1,000 was Ms. Johnson's opinion, that she thought that she should only have to pay a $500 a month. And I would submit to the panel that
Other than the garage door, was there any other condition of the premises evidence that was submitted at the trial court?
there was, with regard to the garage door, Your Honor, there was.
Other than the garage door, was there any other, outside of the garage door evidence? Was there any other evidence regarding the condition of the premises that was presented at the trial court?
Yes, Your Honor. My client's witness testified that none of the conditions that Ms. Johnson was being charged for, that none of those conditions existed at the beginning of the tenancy. And she also testified that, in her experience, all of the conditions were above and beyond ordinary wear and tear. So there was testimony about those conditions, including the garage door. So with regard to the rent issue, based upon the actions of the parties, the pattern, the practice, I think it shows clearly that the intended monthly rate of rent was $1,000. It's just simple math. 20 months times $1,000 is $20,000, less her $7,700 in payments equals $12,300, which is what the court, I believe, correctly awarded for past due rents. With regard to the utilities, again, I think the lease, although, again, it wasn't signed, I think it shows the intent of the parties. The lease clearly states that the utilities are the tenant's responsibility. There was testimony that an agreement was reached to reduce the rate of rent so that Ms. Johnson could afford to pay both the rent and the water, which I think shows that was the intent of the parties. Additionally, I think it's important to note that this was a single-family home. There was just one water meter. Ms. Johnson admitted on cross-examination that she consumed all of the water in the home, and she did receive bills for it. I think her argument was because she was getting duplicate bills, she didn't think she was responsible to pay the water. Again, I think that the evidence clearly shows that it was her responsibility to pay the water, and the trial court found the same and awarded $1,450.86 for past due water bills. And I would also just add that I believe that that's a very reasonable amount for 20 months of water, less than $1,500. I wish my water bill was that.
Was the water bill in the lease that wasn't signed, was that part of the lease?
Yeah, yes. The lease said that the utilities were the tenant's responsibility, yes. Lastly, with regard to the damages, again, as I mentioned, there was testimony that none of these existed at the beginning of the tenancy, that they were all above and beyond ordinary wear and tear. The primary issue seems to be this garage door, which it was, in fact, the biggest number in the damages claim, in the physical damages claim. And there was competing testimony on that. And I would just submit to the court that the magistrate who oversaw the trial heard both parties' testimony about that. And I think it's evident that the magistrate found that the plaintiff's testimony was more credible. The trier of fact, as we all know, is in the very best position to assess the credibility of the witnesses. That was done in this case, I believe. And I believe it was really kind of done throughout the entire case. And ultimately, the court concluded that the plaintiff's witness was more credible. And the court awarded a judgment, or awarded damages in the amount of $2169.96. So with that, unless the panel has any other questions, I would just ask the court to affirm the decision of the Hamilton County Municipal Court.
Thank you.
Thank you.
Your colleagues in the 8th Appellate District decided the case of Riley versus Parker. And in that case, they reviewed the content and timing of a notice a landlord is required to provide a tenant before bringing a forcible entry and detainer action. This eviction action, which was mentioned, was initiated wrongfully. The court went on in Riley versus Parker to acknowledge that compliance with Ohio Revised Code 1923-04 is mandatory. And like I mentioned earlier, from there,
But even if all of that is true, the fact that your client is no longer in the premise, doesn't that make that matter moot at this point?
I would ask you to once again review Schwab versus Lattimore, because I think, and it pains me to say this, Judge Painter was right. Judge Painter hit the nail on the head that you have to set some bright line rules. If the Supreme Court gives you guidance, then you need to give guidance to the municipal court and set them straight. And of course, when you hear eviction after eviction after eviction after eviction after eviction, you're not going to read the 3-day notice as a judicial officer, and you're really not going to care about it. And the appellant really ought to bring it up, because it's their art. No, you see, that's actually not the way it is, because a court needs to make sure that they have jurisdiction. And without a proper 3-day notice, the magistrate didn't even have the right to issue a writ of eviction. We wouldn't even have been there on the second cause, because the first cause hadn't even been determined. And to say that she's gone, then no tenant's ever going to get the relief that they need when the 3-day notice in content and timing is wrong. So please take this opportunity to revisit Schwab versus Lattimore, set the bright line test, allow the folks in the other building to have some clear direction, that they don't just grant the writs of eviction, but they actually make sure that they have proper jurisdiction, that the 3-day notice is timing correctly, exclude weekends, exclude holidays. Why was that originally created? So that people could have an opportunity to get to court first if they needed to. We'd ask you to vacate the granting of the writ of eviction and remand the case to the trial court with instructions to file an order that the judgment is reduced in an amount to its properly calculated amount of $2,270.96, which, after appellee who has already taken the $5,000 bond, is more than satisfied. They fed at the trough, and they got more than their fair share. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Have a wonderful afternoon.
Thank you all.
I have a message here with regard to attorney for appellant, so let me see what it says, okay?
Yes, ma'am. I believe that's it, sir.
Oh. Okay. She's asked for the case to be submitted. Are you in agreement with that?
Yes, ma'am.
Okay, thank you so much. Have a wonderful afternoon. And that concludes the hearings for today.